Hi, I'm Scott Kiner. I am your host for this edition of Real Estate Today. This program provides meaningful information to homeowners who are dealing with the real estate crisis. My guest today is a prominent Palm Springs attorney, a real estate attorney and broker by the name of Mitchell Reed Sussman. Welcome, Mitchell.
Good to be here, Scott. Thanks for having me.
If you are a homeowner, when you purchased your home with your spouse or your partner, the escrow company asked you, how would you like to hold title? While it is typical for most deeds to say that they are co-owners and are to hold title as tenants in common or as joint tenants, most homeowners have no idea what the difference is between the two terms. The topic today, for today's show, is the joint tenancy deed and how it saves money and avoids probate. Mitchell, where does the concept of tenant in common and joint tenants derive from?
Much of our common law comes from England, and real property is some of our oldest form of laws, whether it's joint tenancy or tenants in common. That comes from Old English common law.
So what is the difference between a tenant in common and a joint tenant?
This is a very important distinction. Most frequently, deeds are held as tenants in common. This means that a tenant in common who passes away can transfer by their will their interest in the real estate to one of their relatives. A joint tenancy, however, has a right of survivorship, and under a right of survivorship, there is no ability to transfer by will the interest that one who is a joint tenant has in the joint tenancy.
Why is the right of survivorship so important?
The right of survivorship is important because it eliminates the need for probate. The surviving joint tenant will own the real estate outright upon the death of the other joint tenant.
Is the joint tenancy designation only available to people in the same family?
You can make anybody a joint tenant with you. Any living human being can be a joint tenant with you. They do not have to be relatives.
Does the living joint tenant have to probate their interest to perfect their ownership?
Joint tenancy is a fantastic vehicle by which to transfer title without the need for lawyers or for courts.
So how does one perfect their interest upon the death of one of their co-joint tenants?
Upon the death of the co-joint tenant, all the surviving tenant needs to do is secure a death certificate. It does need to be certified. You get a certified copy of the death certificate. You take it to the county recorder in the county where the real estate is located. You record it. Immediately upon its recordation, the surviving joint tenant will be the sole owner of the property.
So what happens if a will contradicts the joint tenancy designation on the deed?
It does not matter what is said in the will. The will does not control. It is what is said in the deed that controls the designation and the bequeathment and the transfer of the property.
Thank you, Mitchell. That was very informative. I'm sure our viewers learned something today that can help them through these very difficult economic times. That's today's show. But before we go, if someone viewing the show or a real estate professional has a particular topic or subject they would like to see on this show, you can reach me by email at scottk@kinercom.com. If you have a question about this show or a question for Mitchell, you can reach him by email at mitchell.sussman@palmspringsLitigationAttorney.com. Thank you for watching.